Good morning, everyone. Can I welcome you all to the Wilberforce Chambers hot topic talk on Univar UK and Smith. It's relatively rare these days for a pensions rectification case to go to a full trial, and the Univar case is the first fully contested pensions rectification case for several years, and also the first since the FSHC Group Holdings case was heard in the Court of Appeal. 3 weeks involved 15 witnesses of fact and 1 expert, and the lengthy judgment of Mr. Justice Trower, delivered on the 19th of June, dealt with a number of interesting issues which we're going to hear about today. Before we begin, can I just say that we very much welcome any questions you may have on the talk, and if you do have a question, please use the Q&A function to ask it, and we will deal with those questions at the end of the talks. Now to the speakers. We're very fortunate to have with us the victorious counsel team to speak on the Univar case. First up is Michael Furness QC, who needs little introduction as he's one of the leading pensions counsel, who's been involved in many of the recent leading cases such as Box Clever, BT and Bradbury, to name only those beginning with B. We'll then hear from Tim Matthewson, who acted as Michael's junior in the Univar case and who has a busy practice in pensions and commercial litigation. So without any further ado, I will hand over to Michael.
Well, good morning, everybody. Thank you very much for joining. I'm just going to share some slides with you so that you don't have to sit looking at me all the time. There we go. Thank you for that introduction, Paul. As you say, Tim and I appeared for the claimant employer company in the Univar case. And we're going to divide our talk, our presentation into 2 parts. I'm going to talk about the rectification issues, and then Tim is going to talk about some defences which the representative beneficiary ran in respect of certain categories of members, which raise some issues around the construction of opt-out arrangements and the part, if any, that estoppel might play in preventing an employer from resiling from those arrangements. Those issues, I think, are potentially significant, not simply in the rectification context. They were run as a defence in our case, but they could arise as freestanding claims, even in the absence of a rectification claim. So just to outline a bit about the background to the case and the rectification issues, the claimant obviously was the principal employer. We had 6 trustees who were the current trustees who were neutral, and the 7th defendant was a representative who represented all of those members who would benefit from rectification being refused. There was a fair amount of money at stake, about just over £23 million in total, turned on whether rectification could be granted. Now, the issue, the central issue really on the rectification side of things was the fact that before the 2008 deed, which affected the amendments in question, the effect of the scheme rules was that statutory indexation and statutory revaluation of deferred pensions were simply incorporated wholesale. They were explicitly incorporated in the revaluation rules, and nothing was said about mandatory increases in the indexation rules, so the statute simply overrode the rules. And of course that meant that as the statutory regime changed, the rights of members got better or worse depending on the alteration to the statutory regime. What happened in the 2008 deed was that the then basis of indexation and revaluation, which was an RPI-based approach, was written into the rules. There was, as one often finds, a definition of the index, which was defined in terms of RPI, and from then onwards, revaluation and indexation had to be implemented by reference to RPI, even though the the statutory regime might change. And of course, from 2011, from 1st January 2011 onwards, it did change so that indexation and revaluation were linked to CPI rather than RPI. And as you will all be well aware, that has very significant cost consequences for schemes. And that was the basis, that was the reason why the employer wanted to get rectification, because it wanted to go back to the pre-2008 position, where that move from RPI to CPI as the basis of the index would have happened automatically under the earlier rules. There was a power in the rules for the trustees to agree to a change in the index, but the trustees, perhaps understandably, didn't think it was appropriate for them to assist the employer to get rectification by agreeing to change from RPI to CPI, and effectively told the employer that if it wanted to make that change, it would have to go and get rectification. Now, in some ways, the Univar rectification claim was quite conventional, as we'll see in a moment, as I'll explain in a moment. It was one of those cases where the rectification case was no change was intended. This was intended to be a consolidation with limited changes, and the change to the indexation and revaluation rules was not on the list of limited changes. But in some ways, it wasn't an entirely straightforward claim. The first reason why it wasn't straightforward was, as I've already said, the 2008 deed did incorporate the terms of the actual indexation and revaluation provisions as they existed in 2008. So the deed itself didn't make any change to the level of indexation and revaluation. It wasn't until 2011 that a divergence appeared between what was in the 2008 deed and the statutory regime. So that enabled the Rep Ben to say, well, you know, this was simply giving members their actual benefits. Nobody was thinking at the time about whether or not they might change in the future. It's simply putting into expressed words what was already there anyway. So it wasn't really a change, that sort of argument. The second slight problem was that this wasn't a case, as one sometimes finds, where the relevant wording was overlooked by everybody. In fact, the relevant rule in the 2008 deed, which dealt with revaluation indexation, had been pored over quite extensively by the trustees with the help of their advisors. Everybody, I think, was familiar with the wording. It was amended to deal with certain pro-rating issues, and then the draft was amended again to deal with the start date of the annual increases. So this was not a case where the unintended rules slipped through completely unnoticed. Thirdly, the evidence was that none of the trustees or the employer decision makers really gave any thought to the possibility that the statutory regime could ever change. And finally, and negatively, there wasn't any helpful post-execution evidence. You'll be aware that in many of these rectification cases, an unintended change is made, but the scheme carries on being amended as if no change had been made, carries on being administered as if no change had been made at all. And you can point to that following the Galahad decision as evidence that there was no intention to make the change. But there was no evidence of this sort here. When the government announced that they were going to move from RPI to CPI, that caused no ripples on the administration of the scheme. The change was made by the actuary without comment, and it was only a year or so later that the point first came before the trustees and was discussed. So there was an absence of that kind of helpful evidence. When I was preparing this case, my concern really was, and one always gets unduly worried perhaps about the weaknesses in one case, but my concern was what really was the mistake here. Because for any given decision maker in this case, there are a number of mistakes that could have been made. I mean, they could simply have read the new rule and thought, well, that's all right, because we didn't really appreciate that the statutory regime could change at all. Secondly, we could have a a situation in which the decision maker said, well, what we didn't realise was that the old rules would change as the statutory regimes were altered. In other words, we thought the old rules had the statutory regime written in as well as the new ones. Or was the mistake simply that they didn't realise that the new rules would not change as the statutory regime were altered? And my concern was that if the defendant started burrowing down in cross-examination into precisely what mistake each individual member made, they might get a range of different answers, as between A, B, and C, which could then be used to prise open our case that all of the decision makers had a united front in not intending to make the change. And there would have been, I think, an interesting contest, because there was some suggestion in certainly in one of the key witness statements that there might have been a mistake, in the sense that one of the key decision makers did not realise that the old rules would change as the statutory regimes were altered. In other words, it might be said, well, his intention, he did intend the new rule, and he intended the new rule because he thought it was the same as the old rule, and that his mistake was a mistake about what the old rule said and not a mistake about what the new rule said, and he actually intended to do it mistakenly, but still intended to do what the new rule said. So that was the kind of issue that was lurking in this slightly unusual type of mistake in this case, and the approach that we took was to try and sidestep those kinds of questions about what the mistake was, and just hammer away on the fact that there was no relevant intention to make the change, relying on the industrial acoustics of Crowhurst case, Mr. Justice Voss, as he then was, and a helpful dictum from Mr. Justice Henry Carr in FSHC first instance, where, if I get my notes up, he said, sorry, I've just, my notes are on another screen, I just succeeded in locking it. Yes, so Henry Carr said, the authorities illustrate the proposition that where an important change is made to an existing arrangement between the parties, the absence of any discussion of the change itself may be evidence the parties did not intend it. Whether that is true depends on all the circumstances. So we were very much, we were very much running the case that this was simply a case of no intention to change. And we were assisted in that by the fact that in 2007, February 2007, the trustees reviewed the entire draft, it wasn't quite the final form, but nearly, with a very comprehensive schedule of changes that went with it, drawn up by the solicitors, who prefaced it by saying that this is a consolidation, there's no intention to make changes that aren't on the list, and then there was a very long list of changes. Unfortunately, we were able to bring all of the decision makers around to the required position, as far as we were concerned, by showing them this document and saying, well, isn't that what you intended? And of course, they all said, yes, it is. We intended to make these changes. We didn't intend to make any other changes. And in the end, that was the approach which the judge found. He found that all of the trustees and the company decision maker as well, who'd executed the decision of the deed on behalf of the company, and had also seen this solicitor's document, they all intended to stick by what the document said. And so by taking that line, we were able to, as it were, sidestep some of the more potentially awkward questions that might have arisen about precisely what the mistake was that individual decision makers might have made. Of course, there was discussion about FSHC, and there were no surprising observations by the judge about FSHC. FSHC really is the last word in contractual, in the approach to contractual rectification. You will all be aware, I'm sure, that the Court of Appeal said that they agreed with the earlier pensions cases, starting with AMP and Barker, which said that no outward expression of accord was required in a pensions rectification case, where it is simply a case of two parties agreeing to make exercise a power of amendment as opposed to two parties entering into a contract. So the earlier cases on the correct approach to pension scheme rectification, AMP and Barker and Gallagher and Drake and all those cases remain intact. The key issue in FSHC focused on Lord Hoffman's, as they found, innovation in insisting that in contractual rectification, the outward expression of accord, which has to be shown in order to get contractual rectification, was the sole source of determining what the common intention was, and that an objective construction of the outward expression of accord told you what the common intention was, and the parties' subjective intentions were of no consequence. And that approach was decisively rejected in FSHC. And there's a lot of discussion in FSHC about the difference between the subjective intention of a party, which is their real intention, and the objective intention, which is Lord Hoffman's objective construction of the material which constitutes the outward expression of accord. All I'd say about FSHC, and it's a point which we made and was accepted by the judge in Univar, is that the use in FSHC of subjective and objective is different to the use which is sometimes made of those expressions in the pensions context. In AMP and Barker, in particular, Mr. Justice Lawrence Collins, as he then was, talks about subjective intention and objective intention. But there, in the pension scheme context, that is the difference between an intention which is subjective in the sense that it is not evidenced by any outward statement of the intention. So there's no, it's an intention which is solely locked in the mind of the decision maker, and an objective intention, which is one which is which can be demonstrated by what the decision maker said or wrote at the time. So that's a slightly different distinction between subjective and objective to the way that those concepts are used in FSHC. I just point that out because it is possible otherwise to, when applying FSHC to the pensions context, to get rather confused about what FSHC is trying to say. It really isn't addressing the pensions context issues. Now, a couple of points of interest. Let's skip over it. One point that came up and was the subject of quite a bit of argument, although unhappily not very much was said about it in the judgment at all, was how to ascertain the intention of a body of persons, such as the trustees or a board of a company. And this comes back to my concern, which I articulated at the outset, that it might be the case that different trustees had different intentions. So they were all unanimous in wanting to execute the 2008 deed, but it was at least theoretically possible that some of them might have actually intended it to do what it did, for good reason or bad, whereas some of them didn't. And so the question is, where you have a body of trustees, as it happened, these were individual trustees, it wasn't a board of a trustee company, how do you ascertain the collective intention? Because AMP and Barker and the cases following it, the IBM rectification case, Mr. Justice Warren cites with approval chunks from AMP and Barker and takes exactly the same line. It's all about the collective intention. So we were saying, well, collective intention is effectively must effectively objectively be manifested. Mr. Justice Lawrence Collins in AMP said it will usually be, but we were saying that there is such a thing as a collective intention. And you can get that by looking at the minutes, by looking at the papers which the individual trustees considered. That is their collective. If you can show that there was a collective intention there, the fact that individual trustees might, in their own minds, not have signed up to that intention or had a different intention is irrelevant. On the other hand, the Rep Ben was saying, well, the collective intention means that all of the trustees have to have the same intention. So even if there's only one or two who can be detached from the common approach, you have a different intention, you do not have a collective intention. And then, of course, the middle ground is, well, maybe it's a majority that have to show that if you've got a majority for your particular intention, you you have to go with that as the collective intention. As I say, there was quite a bit of argument about that. The judge made one observation about it, which I think was not. He was clearly not about to get into any esoteric arguments about what the right answer was, because he said that all the trustees had the same intention, so he didn't need to address the issue. So the judge, this is paragraph 209 of the judgment, cites the classic statement of Mr. Justice Lawrence Collins in AMP, in which he says the certainty of transactions would be undermined if the court could act otherwise than in exceptional circumstances simply on the assertion of a party to the transaction. And that's, in other words, a subjective approach. But when one is considering the intentions of a collective body, such a group of trustees or a committee of a board, it is their collective intention which is relevant, and it will be a very odd case, and certainly not this one, if that collective intention were not objectively manifested. And then he says that he agrees with my submission that when Mr. Justice Lawrence Collins refers in this passage to objective manifestation, he's concerned with the evidential question of how the intentions of a body such as a group of trustees or committee of a board are established. And this will normally be by, or at least with the support of, documentary means. He is not suggesting that the intention itself can be objective, but because the court is required to identify the collective intent of a body of individuals, the manifestation of that intent will most clearly be established by the documentation with which they were provided. So he is saying that what matters, and he says elsewhere, what matters is the subjective intention of the trustees in the FSHC sense as to what they actually intended to do, even though almost certainly that will be determined by the objective documentary record. But this leaves open the question of a situation in which you have some trustees who come along and say, well, notwithstanding the documentary record, that's what the documentary record shows is not actually what I intended to do. Subjectively, I intended to do something different. And the outstanding debate, I think, is between our position in Univar, which is that for a collective intention, which is more than the aggregate of adding up all the individual intentions, you really have to go with what collectively was put before the decision makers and what collectively expresses their decision. And the approach which the Rep Ben was taking, which is that it is an aggregate of individual decisions, and you have to make sure that each individual trustee has the same intention. It is it remains, I'm afraid, an open issue, but one which is at least ventilated in Univar, even though not determined. And the other, I think, point of interest is the discussion about the issue which quite often comes up in these cases as to whether mistake was one as to consequence or as to legal effect. That again goes back in part to a dictum of Mr. Justice Lawrence Collins, in which he draws attention to that distinction. Have you made a mistake about what the document was actually supposed to do, or have you simply made a mistake about the commercial or legal consequences of what the document is going to do? The Rep Ben's position was, well, this is simply a mistake about consequences. Everybody intended that the rule should say what it said. They all read it, they all understood it. How can they say that they didn't intend to do it? The only mistake they made was that they didn't realize that it would have the consequence that if the statutory regime changed in the future, then there might emerge a dislocation between what the rules provided and what the statute provided for. But they said, well, that's simply a mistake as to consequences. The judge didn't accept that. He pointed out that it was perfectly possible to get rectification in a case where the parties fully intended to use the the terms of the rule in question, but that it had a legal effect which they didn't intend. Allnut and Wilding was a case relied on by the Rep Ben. That was a case of a private trust where the settlor set up a discretionary trust where he should have set up an interest in possession trust, with the result that he had that there were undesirable tax consequences when he put assets into the trust. It was argued that he should have rectification because he intended to have a trust which would give him the tax consequences that he wanted. And the court said, no, that's simply a mistake about consequences. You intended to have the trust you wanted. You simply misunderstood what the tax consequences would be when you capitalize the trust. On the other hand, there's what I think is quite an interesting case of Chinook and Hokhauglu, or however it's pronounced, which is a decision of Mr. Justice Blackburn, about a tenancy renewal where a date was inserted which the parties fully intended to constitute the date they wanted, but they were actually intending to insert a date which was 28 days after a prior event, and they'd made a mistake about the date of the prior event. And the judge said, well, their intention was to have a date which was 28 days after the prior event. Now that we know the prior event was on this date, 28 days is now pushed further back. And even though they intended to use the date which appeared in the agreement, I can rectify it to put in a completely different date because they had an overriding intention, which in fact contradicted the date they had chosen. So in a way, that's quite an extreme case, I think, of saying that the parties you can get rectification if the legal effect of what you've done, or in that case the factual effect really, is incorrect. So that was the other point of interest, I think, on the rectification side of things. So I think that's really all I wanted to say. I probably used up my time allocation now. So I'm going to stop sharing my screen and hand over to Tim.
Thanks, Michael. Let me start by sharing my screen so you can see the slides that accompany this part of the talk. So I'm going to talk about a number of defences that were raised by the representative beneficiary to the company's claim to rectification based on documentation that was issued to members after the execution of the 2008 deed in the course of an opt-out exercise in 2010 as part of the closure of the defined benefit section of the scheme to further accrual. In essence, as I'll come on to explain, the Rep Ben contended that statements in the documentation issued to members as part of the opt-out exercise gave rise to legal or equitable rights that were inconsistent with the form of rectification sought by the company. In particular, the members were said to have obtained rights, the revaluation of their deferred pensions to be calculated by reference to RPI, whereas, as Michael has explained, the company's rectification claim sought to substitute statutory revaluation, which is currently calculated by reference to CPI. The members' alleged rights to revaluation calculated by reference to RPI were said to be a bar to the rectification claim. Now, as Michael touched upon at the start of his talk, these arguments are, I would suggest, of general interest for pensions practitioners, although the way in which they arose in this case was as a defence to a rectification claim, and the way that they arose was perhaps slightly unusual. Opt-out exercises of themselves are common, and the idea that members can sue on statements in the documentation that turn out not to be strictly accurate is concerning for employers who undergo these types of exercise. The issue is not dependent on the rectification background. Suppose that the 2008 deed itself had correctly replicated the statutory regime, but the opt-out documentation was in the same form as reality. The same question of whether the members obtained legal or equitable rights to benefits better than those provided by the rules of the scheme would still arise. So this is a question that might arise more generally. I should explain the nature of the opt-out exercise that was gone through by the company in this case in a little more detail. In late 2009, so about 18 months after the execution of the 2008 deed in respect of which rectification was sought, the company decided to close the defined benefit section of the scheme to further accrual. The reasons for that were the classic reasons that the cost of the defined benefit section was too great for the company, and there was a large deficit. It stood at about £80 million. As part of the closure of the defined benefit section of the scheme, the company wanted to break the final salary link so that pension benefits would be based on salary as at the date of scheme closure to further accrual rather than on the member's final salary. The problem for the company was that although the defined benefit section of the scheme could be closed to further accrual by a deed of amendment agreed with the trustees, there was a recourage restriction on the power of amendment, which meant that the final salary link could not be broken by a deed of amendment. The solution was to undertake an opt-out exercise where members were invited to elect to opt out of active membership under the scheme rules, which would have the effect of breaking the salary link. Members were encouraged to elect to opt out by the offer of membership of the market-leading money purchase section of the scheme. Members were also told that if they did not elect to opt out, they would not be entitled to join the money purchase section, and the company would seek to take other steps to break the final salary link. As I will come on to, one of the issues relevant to the estoppel defence was whether the company would have succeeded in breaking the final salary link for members who refused to opt out of the final salary section. The options on the table are set out on the slide there. They were firstly to make all future salary increases dependent upon the member agreeing that they would be non-pensionable, and that was the tactic upheld in the Bradbury and BBC litigation, which you've heard that Michael was involved in. And the second option on the table was to dismiss and re-engage on new terms any member who refused to opt out. So that was the proposal. The opt-out exercise itself was implemented by 3 key documents that were all sent to members at or around the same time. There was an opt-out form in which the member could tick a box to elect to opt out. There was secondly a covering letter which enclosed the opt-out form and provided some further information. And thirdly, there was a presentation that was given to the members explaining their option in a little more detail. And broadly, the effect of these documents was to give the members 2 options, which are set out on the slide. Option 1 was to opt out of active membership, become entitled to a deferred pension, and to join the money purchase section of the scheme. Or option 2 was to refuse to opt out and to thereby retain the salary link, but the member would have no entitlement to join the money purchase section, and the company said that it would seek to take such other steps as were necessary to break the final salary link. So there was two choices, but because the company indicated that it would take steps necessary to break the final salary link, it was set up to encourage members to choose option 1 to opt out rather than option 2. Now, critically, and this is really the key point that arose in this case, is that the documentation went on to contain a description of the deferred pension to which members who opted out would be entitled. And the key wording, which this whole argument was really all about, is on the screen. It's a few lines in the opt-out form that said this: "My deferred pension will be increased from the closure date until normal retirement date, broadly in line with inflation, critically as measured by the retail prices index, up to a maximum of 5% each year for most of my pension." And there were in fact similar statements to this one in both the covering letter that accompanied the opt-out form and in the presentation that was given by members. And the crux of it was this: the Rep Ben contended that the meaning of this statement was that revaluation of deferred pensions of opt-out members would be calculated by reference to RPI and not by reference to any other metric such as CPI. And it was contended that the opt-out members obtained legal or equitable rights to revaluation calculated by reference to RPI on 3 alternative bases. On the basis of this wording, it was said firstly that the opt-out form created a contract between the member and the employer to the effect that in consideration for opting out of the defined benefit section, the member was entitled to pension benefits on the terms set out in the opt-out form, which included a right for revaluation of deferred pensions to be calculated by reference to RPI. The second way of putting the same argument really was that the opt-out form evinced an intention to exercise the company's power under the scheme rules to determine that the rate of revaluation would be increased and calculated by reference to RPI. And the third way of putting it was in estoppel. It was said that the company was stopped from resiling from its representation in the opt-out form that revaluation would be calculated by reference to RPI. And the doctrines relied upon were alternatively proprietary estoppel, promissory estoppel, estoppel by representation, and even estoppel by convention. So there was a whole host of equitable doctrines on the table, which was said to be invoked as a result of these words in the opt-out form. And the Rep Ben argued that these rights were inconsistent with the rectification claim, which sought revaluation of deferred pensions to be calculated by reference to the statutory basis, which, as we know, since 2011 has been CPI. And as I said, the importance of this issue is not necessarily limited to defences to rectification claims. And these types of arguments that legal or equitable rights have arisen are potentially applicable to other opt-out exercises where the description of benefits in opt-out documentation is not strictly accurate. So turning then to the substance of what was argued, the judgment of Mr. Justice Trower firstly addressed the contract argument, which was to the effect that the opt-out form was a contract between the company and the member, which gave the member contractual rights to better pension rights than those provided by the rules of the scheme. Now, whilst it's well established that it's possible for a member of a pension scheme to become bound under an extrinsic contract with the employer to accept benefits less than those to which he would be entitled under the rules of the scheme, and the leading authority, which I'm sure everyone's aware of, is South West Trains. There is, by contrast, a lack of authority in support of the proposition that an extrinsic contract with the employer may entitle a member to receive benefits that are more than those to which they would be entitled under the scheme. Now, the judgment appears to approach the issue on the basis that there's no theoretical bar as such to an extrinsic contract between an employer and a member that provides for the member to receive more generous benefits than those provided by the rules of the scheme, but that applying cases such as IMG and Gleeds, it would be necessary for the party arguing for the contract to show an intention to create contractual relations so that the contract is binding, even if the terms differ from those of the applicable trust document. And I would suggest it's unlikely in practice that an employer will agree to create contractual rights to more generous final salary benefits outside the parameters of the scheme rules and without the agreement of the trustees. Now, the judge concluded in this case that the only contractual promise that was made by the company to the opt-out members was that they were entitled to join the money purchase section of the scheme. There was no extrinsic promise to the effect that revaluation of deferred pensions would be calculated by reference to RPI. The most important reasons for the judge's conclusion were firstly that the term proposed by the Rep Ben, i.e. revaluation calculated by reference to RPI, reflected both the statutory regime and indeed the unrectified deed at the time of the opt-out form. The judge said that it was inherently improbable that the company would make a contractual promise to provide something that was already part of the scheme benefits at the time of the statement. Secondly, the judge said that the wording in the opt-out form was too vague to have contractual effect. And if I flip back to the previous screen, if you read the words carefully that were relied upon, you'll see that the description of pension increases was that they were to be broadly in line with inflation, and they were up to a maximum of 5% each year for most of my pension. And the judge considered the words broadly and most of, and he concluded that these words suggested that the true intention in this case was to provide a broad summary of the benefits provided by the rules of the scheme, but not to promise something different than was in fact provided by the rules of the scheme. And the third key reason for the judge's conclusion was that the presentation given to the members as part of the opt-out exercise stated that what was said in them was a summary of the existing and proposed provisions of the scheme, and that they did not override the 2008 deed. Now, although this wording was not repeated in the opt-out form itself or in the covering letter, the fact that the presentation was expressed in these terms was inconsistent with an intention to create contractual relations. So the thrust of the judgment is that the statements in the opt-out form and in the covering letter were simply intended to be a broad description of the benefits provided by the scheme rules, and were not intended to override the scheme rules in the event of a discrepancy between the two. Now, whilst this result depended on the precise wording of the documentation in question in this case, I would suggest that the approach in general is a helpful one for employers. It recognises that documentation produced as part of this kind of exercise will often not be intended to create contractual relations that are binding, even if the terms differ from the applicable trust documents. The next argument of the Rep Ben was that the statement in the opt-out form was a valid exercise of the company's power under the scheme rules to increase the rate at which deferred pensions were increased. I don't need to spend long on this argument because there were two short answers to it. The first is that to exercise a power, it's necessary to evince an intention to exercise that power. That argument didn't get off the ground in this case for the same reasons that the judge rejected the contractual argument. In other words, having gone through the contractual analysis and found that there was no intention to create legal relations, it followed for very much the same reasons that the company had not evinced an intention to exercise a power to the same effect. And the second reason is that in any event, to validly exercise a scheme power, it is necessary to comply with the preconditions to the exercise of that power. The preconditions to the exercise of the power in this case included taking actuarial advice and obtaining the consent of the trustees, neither of which were satisfied. This part of the judgment is a reminder that preconditions to the exercise of scheme powers, including in particular the obtaining of professional advice, need to be strictly complied with. And the final principal argument of the Rep Ben was that the company was stopped from denying that deferred pensions of the opt-out members were to be calculated by reference to RPI. Now, although the case was put on the basis of a number of different estoppel doctrines, proprietary estoppel, promissory estoppel, estoppel by representation, and indeed estoppel by convention, it's fair to say that both parties and the judge in his judgment took the legal argument on estoppel at a high level of generality. Following the approach of the Court of Appeal to estoppels in the pensions context in Steria and Hutchinson, the judge focused on the three what he called classic requirements of, firstly, a clear representation or promise, secondly, reasonable reliance on the representation or promise, and thirdly, detriment suffered as a result of the act of reliance. Firstly, focusing on the imprecision of the language in the opt-out form itself, which we've already looked at, the judge found that there was no clear and unequivocal representation to the effect that revaluation of deferred pensions would be calculated by reference to RPI. So the estoppel claim actually fell at the first hurdle. And the judge nevertheless went on to consider the other elements of the claim. The Rep Ben made an interesting submission that as a matter of law, there was a presumption of reliance. So it was to be presumed that the members had relied upon the representation in the opt-out form, and that the burden was on the company to disprove reliance. The judge disagreed with that approach. He said that it all depends on the factual context and the nature of the representation or statement relied upon, and whether it's one that would be expected to induce the relevant conduct. So it's a question of materiality. In the present case, the judge did not think that a statement that revaluation would be calculated by reference to RPI would have been likely to have been a significant factor in a member's decision to select option 1 on the opt-out form rather than option 2 on the opt-out form. And he reached that conclusion after hearing evidence from a number of members on the issue, including one member that the Rep Ben did very well indeed to find, who professed to have, he said in cross-examination, a slightly geeky interest in economics in the recession of 2008, and he knew all about the differences between CPI and RPI. But even his evidence did not persuade the judge to find that there had been reliance. And finally, the Rep Ben did not succeed on detriment either, because if one or more of the affected members had selected option 2 and thereby refused to opt out, the judge found that the company would have done what was necessary to break the final salary link. As I said at the start of my presentation, the options on the table were either to follow the fire and rehire approach, or to make any future pay rises conditional on agreement that they would be non-pensionable. And the judge thought that one of those approaches would have in fact been followed by the company. So the members were in fact no worse off by reason of electing to opt out. The breaking of the final salary link would have been imposed on them anyway. So to summarise, the judge's general approach to this issue in Univar was helpful to employers. It recognised that documentation produced as part of this kind of opt-out exercise will often not be intended to create contractual relations that are binding, even if the terms differ from the applicable trust documents. The judge also rejected the presumption of reliance raised by the Rep Ben in the context of the estoppel argument. Nevertheless, to avoid these kinds of arguments that were raised in the Univar case, a practical takeaway for practitioners is that it is prudent for all documentation produced as part of an opt-out exercise, including the opt-out form itself, to include wording to the effect that in the case of inconsistency, the rules of the scheme will prevail. So that is my overview of the Rep Ben's defence based on the opt-out exercise. And now I'm going to unshare my screen and hand back to our chair to see if there are any questions for us to discuss.
Thank you very much, Tim. And thank you both. We do have time for a couple of questions, which attendees have very helpfully sent on the Q&A form. The first, which I will now put up on everyone's Q&A screen, is from Catherine Lloyd. And I think this is probably one for Michael. If another scheme has the same issue, can the trustees administer it as if it's been rectified? In other words, that statutory evaluation stroke increases will apply rather than RPI without applying to court for rectification, given the Univar decision?
Yes, well, thanks, Catherine. I think this is a question that quite often comes up when one is advising on rectification. Well, do we really need to do this, or can we just proceed on the assumption that the case is so clear that the employer can get rectification whenever it wants, and we'll just carry on administering the scheme regardless? The classical learning on rectification is that you need an order in order to perform the magic of rectification, which is retrospectively to rewrite the rules back to the date when the mistake was made, and that if rectification is not actually obtained, as long as rectification is not obtained, the members are entitled to their benefits in accordance with the terms of the rules. So that puts the trustees in a rather difficult position, I think, and one which most trustees are not prepared to go along with, which is that they are committing breaches of trust on a routine basis by paying benefits at a lower level than members are entitled to under the rules, without they or the employer having got the necessary order which justifies them doing it. Now, you might do it on the basis of a very reliable indemnity from the employer against any loss, but as I say, it's not a happy state of affairs with the regulator looking over your shoulder and the ombudsman available to assist the member, because the ombudsman will take no notice at all, I think, of the possibility that you might be able to get rectification. It's not a happy position for trustees, and in my experience, they're not advised and are not willing to go along with as it were, what might otherwise seem a rather practical approach. However, let me just draw your attention to, there is a tax case called Lobler and HMRC, and that was a decision of the upper tribunal, Mrs. Justice Proudman, It's 2015 UK UT 1052. And that was a case where the taxpayer needed rectification in order to get the tax result he wanted. His problem was that the first tier tribunal and the upper tribunal don't have jurisdiction to grant rectification. So he was saying, well, I should be taxed as if I'd got rectification because I can show that if I applied for it, I would get it. And paragraph 50 of her decision, Mrs. Justice Proudman accepts that argument. She says that rectification is the same as specific performance. We're all familiar with the idea that specific performance, equity looks on has done what ought to be done, and therefore beneficial ownership is regarded in equity as following the ability to claim specific performance, Marshall, Lonsdale, etc. And she said she couldn't see why rectification was any different, and therefore if you had a case for rectification, you could effectively treat your documentation as if it had already been rectified. HMRC disputed that, but didn't appeal it. It has to be said that the taxpayer's moral case was extremely strong in those circumstances. But I'm not sure we've heard the last of that in the tax context, and I'm not sure that I agree with it in the pensions context, but there is a case out there which does indicate that what I've called the traditional classical view of rectification, that you need the order, is not necessarily correct. So there you go.
Seems to me, Michael, that the difference between the specific performance analysis and the rectification analysis is that with specific performance and the Walsh and Lonsdale doctrine, you've got a concluded contract or a concluded lease on which it's plain, or ought to be plain, whether or not the specific performance can be granted. The problem with rectification is it's so based on evidence, and the longer you leave it,
yeah, absolutely,
the chances is the evidence is going to be lost, or people are going to forget about it.
I entirely agree, Paul. I think that the analogy which the upper tribunal in Lobler draws and says, well, they must be the same, is a false one for exactly the reason you give. But there it is.
Okay, thank you for that. And one final question from Arshad Khan, which I will now share with you. This one is for Tim, I think. If the opt-out wording that you discussed earlier did not include the words broadly or most of, would that have made a difference to the judge's decision on the contract argument? Or was he sufficiently against the concept of contractual intention that he would have found no extrinsic contract in the circumstances of the opt-out exercise?
Well, that's a difficult question in some senses, because we need to hypothesize what the judge might have thought if the contract had said something else. It's true to say that in this case, the judge attached some weight to the fact that the opt-out form included the words broadly and most of, which suggested to the judge, in my view rightly, that what was going on here was that the employer was simply trying to set out a broad description of the benefits provided under the scheme rules. That said, the judge relied on a number of other factors in addition to those particular words in the opt-out form to reach his conclusion that there was no intent to create a relevant contract in this particular case. And my reading of the judgment is that probably in the context of this particular contract, there were enough other pointers away from contractual intent that whether or not these words had been included, there was probably enough to persuade the judge that there was no intent to create a contract, that revaluation would be provided on a particular basis. But that's not to say that the same conclusion will apply in all cases. It will always obviously depend on the precise wording of the documentation in question. In any particular case, one will have to hone in on the precise words and what the purpose of the particular document is. But I think it's true to say that the judge was alive to the fact that an employer will not necessarily have a contractual intention, and that really what's going on is that an employer might simply be trying to provide a broad description of the benefits under the scheme.
Thank you very much, Tim. Well, thank you for that. Can I conclude by thanking everyone for attending? We've had well over 150 people attend this meeting, which I think is testament to the quality of the speakers, which has been borne out by the quality of their talks. Just to let you know that a recording of these talks will be on our YouTube channel, and you can find the link on our LinkedIn page and on the pensions page of our website. You'll also find on our YouTube channel recordings of all the talks from the recent UG lecture series. And all that remains for me is to thank Michael and Tim for their excellent talks, and to thank you all for attending, and hope to see you again soon. Thank you.